on. So correct. Huh? Correct. Huh? That is, Mother, I can remember 17. 17. 17. The matter has become infectious. Okay, right. Mr. Edha. Edha learns counsel for the protection submit that the matter has become infectious. According to the petition is applied. 21. 21. Yes, what about Mr. R.R. Oval appearing for the Forest Department subject that the affidavit has been sent for vetting and will be submitted within within a week. He also submits that he has taken the consent of the other. So accordingly, this matter after it. Right, please. Declaration was item number 9 of the this one. Yes. Yes, nice. This matter has become infrastructure. Right, Mr. FKR. FKR Ahmed, the counsel for the petition, submits the matter of infrastructure. According to the petition, dismissal. You are appearing here, is this item 9? No. No. 30. Mr. Panik is there. Mr. R.R. Boy submits that he has not received instructions. He accordingly prays for another 2 weeks time. Praise it out. This is the matter. Continue. Interim order passed. They have continued till the next. Till the next.
Here, please. Item number 20 meter.
20.
20.
Yes.
It may kindly be listed after 1 week meter because the engaged counsel Mr. Leilal is out of the station and some instructions are to be taken.
Huh?
Some instructions are to be
What is your name?
Yes, M. Pandit.
Huh?
M. Pandit.
Item 20.
20. 20.
Item 20. Okay. No, what is the, it is admitted amount. It is
You know, the
admitted.
respondent has filed the affidavit and some instructions are to be taken.
What instructions are to be taken? Show me item 20.
Because there we found some accounts.
Item 20. When they have admitted, when the respondents have admitted your claim, what instructions do you need?
So he has filed the affidavit meter.
Huh? No need. If it's admitted, we'll allow the petition. No need of adjourning the matter. You wait, we'll see. Next.
Message.
Huh? Yes? You have me confused, okay. Okay, right. Miss A. Chatia, appearing on behalf of the petitioner. Petitioners submit that the matter has become instructed. Accordingly, this petition dismissed as instructed.
I beg to mention item number 22.
Yes,
Sir, Lordship, we have received affidavit in position, we may be granted 2 weeks time to file rejoinder. Lordship.
Surrender.
Yes.
Okay, right. Mr.
KJ Hazare.
AJ
KJ Hazare.
KJ Hazarika, learned counsel for the petitioner, is granted 2 weeks time to file affidavit with reply to the affidavit filed by the state responsible. You've got a restricted bore. Your revolver is a restricted bore, 3/8.
That is the issue, Your Honor.
Then, if it's restricted, then what is to be done? You by your affidavit, you cannot make it a 3/2 or a 2/2. I mean, then if it's a restricted bore, it's a restricted bore. How can you change the caliber of your revolver?
Your Lordship,
This is a huh?
the way it was cancelled is cancelled.
It's not a question of. It could not, a restricted bore cannot be issued by a state government. It can be issued by the center, not by a state government. You cannot have a 9 mm pistol. This is a 3/8 revolver. You can have a 2/2 maybe, but not a 3/8. No case. You wait. What is your name?
KJ Hazare.
KJ Ahmed. No. You wait. Item
22.
22. You wait. Yes. 26 and 27. Yes. Yeah, for the APDCL. Mr. W. Ahmed, appearing for the APDCL submit that he has not received any instructions till date. He accordingly prays for 3 weeks time to obtain instructions and file affidavit. This is the matter. Huh? You're here for whom? I know, I'm talking about him. This is the matter after 3 weeks.
So, Lordship, I'm paying for listing of this big petition.
Huh?
Paying for listing of this big petition for
New case. Regarding what?
land matter.
Huh?
Actually, the petitioner's land has been fraudulently transferred to some other person without the knowledge of the petitioner. So it's regarding land matter.
Bench 5 matter, I think. Go to bench 5. That's why we have to always ask them what the matter is about. They always come here. Only one problem with your matter. What is your house number?
But actually, the party has taken back.
Huh?
Party has taken back brief from me, Lordship.
Party has taken back brief from you.
That's the problem.
Then what to do? Notice has not even been issued. So we dismiss or what?
Lordship, my humble prayer, Lordship, kindly dispose of as my learned friend.
I am not going to dispose of. You cannot say your brief has taken away from you. Who are you to submit them?
Or they may engage any other counsel, some time may be given.
No, there. Why should we dispose of? Have you read the writ petition? Have you seen the contradiction in the address? Then it is the petition itself, they're full of contradictions. Why should we allow? I'll list it on Friday. If the petitioner does not represent it, I'll dismiss it. Right. Mr. M.I. Hussain, learned counsel for the petitioner, submits that the brief has been taken back by the petition. Mr. M.I. Hussain shall accordingly submit an application to that effect, a representation to that effect, with the registry of this court. How you inform them? Pusla. No one appears for the petition. Pusla. A perusal of the affidavit shows that the petitioner's house number is 25 in para 3 of the writ petition. Full stop. However, wait, huh? Where did I see it? I saw it somewhere. However, as per the voter list of 2019, page 17, and the letter dated nil, bracket page 19, the petitioner's house number is 319. As the petitioner is unrepresented, one chance is given to the petitioner to be represented. List the matter on Friday. Okay, Monday. No, you get list on Monday. You file your representation by today to the registry.
Where? It is regarding non-release of the outstanding bill.
Right, heard, Mr. As for our counsel for the petitioner, who submit that the petitioner's contractual dues amounting to rupees 18,33,357 has not been paid. Issue notice returnable in 4 weeks. Mr. R.R. Powai accepts notice on behalf of 1, 2, and 6. What about finance? While Miss R.M. Barwa accepts notice on behalf of fund number 4. This is the matter of the 4 weeks to enable the respondent counsel to obtain instructions and file affidavit.
No, item 5, my lord, exactly same, my lord.
Item 5, same order except 993426.
Problem.
My lord, I have challenged the imprint order at page 22, Lord.
Why was your license cancelled? Because of what?
Because Lordship, allegation is that I have lended money.
You're a money lender.
Yes, Lordship, that is the allegation, Lord. And the allegation is without any basis.
Is this
Lordship, may
matter, is it this bench 4 matter?
Lordship, may kindly see FIR I have annexed. In the FIR, name of a different person's name appears, Lordship.
What is to be done here? Page 50. Yes. Ah, where is? No, but it has been renewed up to 25 February. But he's still innocent, still proven guilty.
Yes, sir.
Right. Heard, Mr.
MI Hussain, Lord.
M.I. Hussain, learn counsel for the petition. Your name is not here. You have submitted Vakalatnama.
Yes, Lord.
Why is your name not listed? M.I. Hussain,
My name is here, Lord.
Actually, it is not here. You heard Mr. M.I. Hussain, learn counsel for the petitioner who submits that the petitioner's license as a temporary license as a petition writer has been cancelled by the order dated 8/3/24 issued by the district commissioner
Yes, sir.
Golpara,
District Magistrate.
district magistrate Golpara. In view of the petitioner having been arrested by the police in connection with Lakhipur PS case number 59/2024 under section 120B, capital B, /420/406/87/506 IPC in connection with the Assam Money Lenders Act 1968. This is at page 22. Issue notice returnable in 4 weeks. Mr. K. Gogoi accept notice on behalf of 2 and 3. While Mr. R. Paul Pujari accept notice on behalf of R1. This is the matter after 4 weeks to enable the respondent
Stay of the impugn order, Lord. Because this is my only.
This is the matter after 4 weeks. This is the matter on give a date. Give a date. The prayer for a stay of the impugn order may be considered on the next week.
Obliged. 24.
Make this election. So now the Fishery Cooperative Society and pursuant to a direction passed by this honorable court in substance that whether of A or B of the fisheries of the society should continue on daily basis pending finalization of NIT, I was allowed to operate on daily basis.
Since when?
My lordship. The order is 24th of December 2019, allowing me on daily basis.
24 December 2019.
Lordship.
And since then you have been daily basis.
That is not to my prerogative, Miller.
Huh?
Up to them to issue an NIT. What I am on, Miller.
In WPC number
WPC number 8467
8467
of 2019.
of
And the
2019.
order is dated 21/11/2019.
Huh?
21/11/2019. That is the order passed in the writ petition
21
11/2019.
page.
It starts at page 70, operative at page 90. May I read the operative portion?
No, basically that
Basic-
till the regular.
A or B, whichever would, and the government carried out an exercise and allowed me to continue. Now, it so happened that in case of a different fishery of Dhubri district, a decision was reached by this honorable court, where correctly or not, we have not challenged that. A direction was issued to the state respondents to have the fishery rules amended or to issue a guideline. But we would challenge that if need be.
Now, can this court decide?
Absolutely. We are on that, but for the present, in the writ petition before the honorable single judge,
Should it go before DV?
but we are not on that. Consequently, actions were taken by them, initiated by them. So, rightly or wrongly, they thought this daily basis system should come to an end. Let us take a deadline and let all go khas. Beyond that, government takes over.
Khas means what?
Khas means that is not under settlement anymore. Possession of the government will manage whatever.
So
Loss of
government
revenue will take.
possession means khas.
That means khas, government would have it, may not be operated.
So what is wrong?
Nothing wrong. Nothing wrong. But may I place an order of the government where they categorize in two parts. Some fisheries are operating on the strength of orders passed by this honorable court, such as ours. And they decide to categorize and keep it off. This, may I read that? This is of 4th of May 2024. May I read? With reference to above, I am to inform you that you were instructed to take steps for taking over possession of government fisheries now running on daily basis after 10th May 24, after casting of votes is over in the entire state on 7th May 24, and keep them as class. In the meantime, take steps for regular settlement of such fisheries through tender system in the light of order of the Honorable High Court quoted above. However, it appears from records that some such fisheries are running as per specific orders of the Honorable High Court. Government is of the view that possession of such fisheries need not be taken over immediately in terms of the order of the Honorable High Court 9/4/24, and status of such fisheries may be submitted so that government may take up the matter of such fisheries with the Honorable Court for further order or instruction in this regard. In this connection, a format for submitting report of all such fisheries now running on daily basis, including those with specific order of the Honorable Court against each such fishery, is enclosed herewith. You're requested to submit status report of all such fisheries as per enclosed format immediately for submission of action taken report before the Honorable Court on the next date in compliance of the order of the Honorable Court dated so and so, as well as instructions in respect of the fisheries running on daily basis as per specific order against each such fisheries as stated above. As regards regular settlement through tender in respect of some fisheries now running on ad hoc system, separate instruction for modification, inclusion, terms of conditions in the NIT is being issued shortly. That's all. What I am on. Government also has realized that there are two categories of fisheries. One running on daily basis as per their initiation, and the other through orders of this court. I fall in the latter, and they are on a conscious decision not to touch this, but submit a report before this honorable court on the touchstone of this, the impugned order.
Okay, Mr. Sharma, why haven't you issued a NIT? Since 2019, court had said that till you issue an NIT, let them carry on. So why have you not issued a NIT now? Till now, 5 years have gone by. Huh? Who is this officer who is allowing this thing to go on? Illegal act in violation of section 12 or regulation, what, rule 12 or what?
Rule 12.
Rule 12. In violation of a specific statutory rule. Who is this officer? Maybe he should come here. Why is the NIT not being issued? Mr. Counsel, the last 3 months ago, you said the same thing to me. Recently, you joined. Or maybe 8 months. No, I'm not on that. I'm on the simple question. In 2019, the writ petition was disposed of, saying that a regular NIT should be issued for settlement of the fishery. And till then, they may be allowed to continue. Why has it not been done till date? Who is this officer? Let him come to the court and explain. Let him come to the court and explain why NIT has not been issued till date. No, we'll take action against this officer.
I'm impugned order is at page 40.
Huh? Yes.
But they are not going for anything, Lord. Whatever has happened, we take it. Yes, yes, now we have not got that.
You're not on what?
It is not clear. After 12 of April,
Mr. Counsel, but the problem is they have been allowed to operate on the basis of a court order. But it did not bar you from from issuing an NIT. Now you have not issued an, why don't you issue an NIT?
yes, yes, we are doing not as per 12 of April. This is not okay.
When will you issue NIT with this? Regard to this.
Yeah, Lord, there is- that is it. Page 40, that order may be stayed in respect of this particular fishery. Absolutely.
No, we'll see. It's not so simple.
Well, look, so far as they are running contrary to their own decision,
We'll see. It's not so simple.
my lord,
Let him appeal practice.
lordship may
You
record
follow.
this document, my lord.
There's another week.
Well, fourth of
Doesn't
May,
matter.
this
Doesn't
document may
matter. No.
no, whatever I placed, my lord, 4th of May.
Maybe we'll refer it to the division bench. Let them take a
Absolutely.
decision.
But 4th of May may be indicated, my lord, in the order. Because this is what I'm saying, they've taken a conscious decision not to touch those which flow from the orders of the honorable court. Yet they are acting contrary to it.
This is 4th of May.
4th of May.
But the subsequent order is of 12th of May.
So
12th
12th of
it is
May-
April. Okay.
How they address your lordships on that. 12th of May is a general order, and 4th of May is a prior order, reflecting that those which are pursuant to orders of honorable court will not touch them. Will submit a report to the honorable court for what can be done. That's what I am on. That's what I'm on. And the order starts with the order.
Anyway, right.
Your lordship indicate this.
Heard Mr. L. Bani. Learned counsel for the petition. Who submit that pursuant to an order dated 21/11/2019 passed in WPC 8467/2019, wherein the wherein this court had directed to take a decision, to take a fresh decision on the point of issuance of a fresh NIT for settlement of which fishery?
My lord, Sessa Nadi fishery.
Huh?
Sessa Nadi fishery of the Dibrugarh district.
Have you got it? And also on the question of whether the writ petitioner hearing or the respondent number 4 in WPC number 8467 of 2019 should be allowed to operate the fishery on a daily basis pending finalization of the NIT. The Fishery Department issued an order dated 24/12/2019 allowing the petitioner to run the fishery on a daily basis till regular settlement of the fishery through tender process was made by the government. Yes, sir. Next paragraph. The grievance of the petitioner is with the order, is with the impugned order dated 18/5/2022, 2024. Is it?
No, sir.
Issued in pursuance to the order dated 9/4/2024, passed in WPC 19/11/2024.
And two more orders. And two more orders. 12/4 and this one, 4/5. It indicates.
Just a minute. Wherein this court has had directed that all fisheries in the state should be settled through a tender process in terms of Rule 12 of the Assam Fishery Rules 1953.
Report, sir.
First off, this court had further observed that because of the system of daily basis settlement of fisheries, timely settlement of fisheries by tender was not being done by the authority, which led to multiplicity of litigation in the court. Consequent to the order dated 9/4/2024, passed in WPC 1911/2020,
Page 38, not 38, 38.
the Fishery Department issued order dated 12/4/2024, stating that settlement of fisheries on daily basis was not commensurate with Rule 12 of the Assam Fishery Rules 1953. As such, the settlement of fisheries on daily basis of 60% fisher category of government fisheries was to be stopped, and fresh tenders were to be issued for settlement of the fisheries.
Then comes 4.5.
Next part.
Taking note of 12.4.
Just a minute, Mr. Counsel. I'll ask you when I need your help. I think I've heard you enough. Next para. The petitioner's counsel submits that besides there being two conflicting orders of the court of coordinate benches of the court. No, we don't say conflicting. The counsel for the petition submits that while the petitioner has been allowed to run the fishery on a daily basis, still a regular NIT is issued. The subsequent order passed in WPC 1911/2020 has stopped the settlement of fisheries on a daily basis on the ground that the same is not provided for under Rule 12 of the Assam Fishery Rules 1953. The petitioner's counsel submits that the Fishery Department has now realized that there are two fisheries, that there are two types of fish, that there are two types of fisheries being run on a daily basis. So step one being run on the on the basis of the orders of the court, while the other being on the basis of the permission given by the fishery officials, fishery department. He submits that in terms of the letter dated 4/5/2024 issued by the Commissioner and Secretary to the Government of the Assam Fishery Department, fisheries running on daily basis on the basis of the orders passed by the court stand on a different footing, and those fisheries need not be taken over immediately in terms of the order dated 9/4/2024 passed in WPC 1911/2020. He accordingly submits that till a regular NIT is issued in terms of the regular NIT is issued by the Fishery Department in terms of the order dated 21/11/2019 passed in WPC 8467/2019. The petitioner should be allowed to continue to run the fishery on a daily basis.
Let it be on Friday or Monday lot, I'll take instruction. Because DC has to take the issue the NIT lot. We are not going to, what is the stage lot? We are only on that part, that if there is any court order, not to take the position lot. Honoring the court order lot. We will come for a petition of this order lot. Actually, sometimes what happens, DC is the party, we may not know that it is a 2019 matter lot. That's a problem.
Yes, sir, right. Mr. P. Sharma appearing for the Fishery Department will obtain instructions as to why no NIT has been issued by the authorities for settlement of the fishery in terms of Rule 12 of the Assam Fishery Rule 1950. Even though this court had allowed for the same. Four-years ago. That is by order dated 21/11/2019. Passed WPC 8467/2019. List the matter on Monday. On which date the prayer for an interim order can be considered by the.
May I pray, Lord? Can this?
Huh?
No.
39. That one you keep it. If you wanted to take it back. Yes.
Clear petition. My lord, the petitioner is challenging an order that final revised final assessment order dated 15/5/2024 for which has been paid for an amount of 3,97 lakh,
Page.
page 114. Page 114.
Yes.
My lord, your lordship will see the first entry of amount is 1,71 lakh. 8,454. Now, this is an amount which was raised earlier, way back in 2016, and that my lord will get at page 95. Page 95. Page 95 is what?
Yes.
There's this same amount, 1,71,000, 1 crore 71 lakh 450. The same amount which was raised by bill dated 26/8/2016. And my lord, here only if your lordship to see the period for which this amount has been charged is mentioned on the top just below the final assessment bill. 22/12/2015 to 5/8/2016. The lordship has seen this 228 days. Now this was
Just a
challenged
minute. For
from
yes, for 228 days. Yes.
yes, 22/12/2015 to 5/8/2016. This was 228 days.
So
So this was the calculation was for this period.
Huh.
Now, we challenged this before this honorable. And that was, my lord, I have annexed the writ petition at page 23. I'll not take your lordship, your lordship may just see. Page 23,
5067.
my lord, 5067.
5067 of
Yes.
2016.
An interim order was issued by your lordship. Interim order, if your lordship can kindly see, is page 97. It starts from 96 and 2016 at page 97. There was an interim order that no coercive action will be taken against the petition. And this was extended from time to time. And the last occasion at page 99, my lord will get order dated 8/11/2016. This interim order was passed earlier shall continue until further ordered. Now, during the pendency of this writ petition, there was a scheme formulated by the APDCL by order dated 4/4/2022. That my lord will get at page 116. 116. Section 13, 116. Empowered committee.
Yeah.
To reduce pending litigation.
Yeah.
Now, then under this offer, we apply. Because this was with the intention to reduce the litigations against APDCL. We apply. Our application is at page 100. Section 4. And the lordship can kindly turn to 100 and 100. The relevant place before lordship is 106. And these are available, downloaded from their portal. And then, my lord, filled up and submitted in that portal. We have taken the hard copy. Now, if my lord will turn to page 106. 106.
Yeah.
The top line, my lord, the applicant is ready and willing to compensate APDCL for the losses, if any, sustained by the region of damage to the CTPT set covering period from 26/7/2006 to 3/8/2016 at normal rate of tariff. Now, my lord, below that, if your lordship will see the declaration, we are supposed to give a declaration because this is a form which is their form, my lord. We download from their format. Declaration says, just 2 lines I want to put. I hereby undertake that all details submitted herein are true and correct. I also undertake to accept the resolution under the scheme unconditionally, withdraw the present litigation, if any, and not pursue the matter any other forum in future. I also undertake that even if non-compliance of the terms of this arrangement under the scheme at any point of time, the amount paid under this scheme will be forfeited and I'll have no claim over it. This is what we have submitted. And this was submitted, my lord, on 26/4/2022. Lordship will give date will be important.
Yes.
Then, my lord, this was the committee which was constituted took a decision. And this resolution was uploaded on their website. And that, my lord, will get at page 106. 707, page NHF 9. Page 107. My lord got it?
Yes.
Resolution. After thorough deliberation on your application, the empowered committee has resolved that the assessment bill of 1,71,08,454 is withdrawn. So the bill was withdrawn. Supplementary bill of 9,72,477 is generated and the consumer is liable to pay rupees 9,72,000 to APDCL. The consumer shall make payments of so and so within 27th March. The aforementioned resolution will prevail only on acceptance from your end. We accepted it. Once we accept, my lord, in their portal, once we accept, an undertaking is generated. And we, again, my lord, agreed, and then we submit it, soft copy as well as the hard copy. So the hard copy, your lordship will find at page 109. 109.
Yes.
This is the undertaking on their format. I hereby undertake that the resolution to the application proposed by the empowered committee by so-and-so is fully acceptable to me. I undertake in the event of non-compliance of any of the terms of this arrangement under this scheme at any point of time, all consideration under this scheme will be forfeited and I'll have no claim over any benefit availed. I also undertake that the matter has attained finality with my acceptance of the
So
resolution.
yes, so
and
you have undertaken, then what happened?
Yes. Now, after this, my lord, after our undertaking, we received, my lord, we received a letter nearly 1 year after we accepted and we deposited the money. Everything was deposited. And your lordship will kindly see at page 110. 110.
Yes.
With reference to above, this is to inform you that Mr. Bridhi Iron is the petitioner before your lordship, has accepted the resolution of one-time settlement scheme, OTSS, empowered committee and payment of settlement of amount of rupees so-and-so in APDCL corporate principal accounts on 16/3/2023. You are requested to adjust the amount against the revised assessment bill of the consumer. The amount shall be reflected in revenue of March 23. The resolution is attached here for your reference. So this was accepted, the matter closed. 16/3/2023. Then after that, we withdrew our writ petition with liberty. Let me please, because one thing which may be necessary, I'll submit, my lord.
Basically, the long and short of it
Yes.
is that the board of directors has to approve the empowered committee recommendation. It's just a recommendation. It is, they are not the ultimate authority.
My lord, page 117. I'll take your lordship to the terms of reference.
Come to 117 clause 8.
8. Yeah, 8 and I have quoted in paragraph 14 of my writ petition. All proposals, kindly mark this.
Yes,
This is a proposal.
yes.
All proposal board of directors by chief general manager in precise manner for disposal on merit of each case. Now, this is at proposal stage, and this is their internal matter. I will have no information that this is not valid till it is approved.
No, you
After
please,
accepting
you
everything.
see, that is your contention now.
Yes.
But you please come to 1112. The withdrawal of your writ
Yes,
petition.
that's right. That's what I wanted to take your lordship through that.
The withdrawal of your writ petition
Yes.
out here, the APDCL council has stated.
Yes, committed that.
The
on
matter is
time
under
on the-
consideration before the board of directors.
Now, my lord, for a second, if you lordship, consider that this is a matter where at the proposal stage, the functioning will be the empowered committee will take a resolution. And before the resolution is given a final effect, it will go to board. That's what my understanding is. And after the board takes the decision, it will be communicated. and then it will be uploaded, and then I will have the right to accept or reject. Here, those things have not been done.
Well, that is the procedure they follow, rightly or wrongly,
No,
they're
but
doing it.
Your
But
Lordship,
what to do? We cannot,
kindly consider one thing. There is an internal arrangement. The proposal stage, it should go. Now, whether it has gone or it has not gone, how the consumer
You-
will
you-
know? This is the
no,
question I answer.
you see, even in the withdrawal order,
Yes.
it has been categorically stated by the APDCL Council that the matter is under consideration of the board. There was no finality then. You knew it at the time you were going to withdraw because the council had stated there that it is still under consideration.
My lord, kindly speak.
If it was if that consideration of the board was not required or did not have any effect, the court could have clarified that issue straight away.
No,
But it has left it an open-ended
my lord,
question here.
what the court has said just below that, Your
Yeah.
Lordship will see, in view of the submission made by Sri Kejriwal,
Mhm.
there is counsel for the petitioner that the matter according to the petitioner has been resolved and the petition stands closed, not pressed, with liberty as prayed for. So why not?
So why was the liberty prayed for? Why do you need liberty if everything was resolved?
Liberty was granted in case board of directors does something adverse. That's the reason, that could be the reason. But
So-
kindly consider this, my lord. There is a guideline where there is some internal procedure to be followed.
Show me that internal procedure.
This is the internal procedure at 114. If the proposal was not there, yes, we would have been wrong. Kindly see 117. Kindly see the meaning. The proposal has some meaning.
But then, you see, we will have to see whether the proposal of the empowered committee had been placed any time had been placed any time before the board and it had been accepted and thereafter that issued those letters of acceptance.
My lord, I just consider one thing. This is the proposal. At this stage, I don't know what is happened, what is transpired. What I know is that some resolution is downloaded on their portal. I accept it and I take action. And this has happened, my lord. This order of the board of directors is nearly 1 year after the matter was settled. 1 year after the matter was settled. So, if really any problem in their internal matter, my lord, because, my lord, if at 117 it was mentioned that the final decision will be taken by the board of directors. Then the resolution would have said so,
No, out here,
that it has been approved by the
see,
board of directors.
you see, this terms of reference clearly says
Yes,
for disposal.
yes.
So basically, it amounts to saying that the board of directors shall have the final say.
Well, kindly consider, it may have final say at the proposal stage. At the proposal stage, they can do anything. Then I would have continued.
No, but what happens if the empowered committee had taken a decision without going through the board of directors? Then what happens?
Internal matter, what action they have taken against the empowered
So
committee?
let us hear them.
What action they have taken?
So let us hear them.
Because, just 1 minute more, I'll take. Suppose, by law, there is an internal procedure of which the person who is going to be affected, consumer in this case, will not have any knowledge. He cannot have any knowledge. It comes on in a form of resolution. I accept it. I give an undertaking. Undertaking says you withdraw. If I don't withdraw and wait for this decision, which is at proposal stage only, then what happens? What follows? As per my undertaking, they will forfeit everything, whatever I have deposited if I don't withdraw. I have read it out because of that. Can you see the undertaking? Can you see the undertaking? page 109. Page 109, madam. Third paragraph at page 109. I also undertake that the matter has attained finality with my acceptance of the resolution, and I concede my right to pursue the same before any other forum. I also undertake to withdraw immediately all matters being presently pursued. Now, if I don't do and wait for 1 year, they will cancel everything.
So this is a prescribed format made by them or what?
Yes, made by them. It is, these are available at the APS portal. Everything is my
Page 109.
undertaking. Everything is there. Everything is there. Your Lordship will call the resolution. Your Lordship will see. Because after everything is taken, if if they are at fault, they should have dismissed the chief general manager, who is the chairman of the committee, that you have not followed the rule. But I am being made to suffer. And kindly see one more thing. Earlier, I was saddled with a liability of 1,71 lakhs and odd. Now they have added surcharge of 3 crore, of 2 crore something on during the period when the petition was pending before your Lordship, and as well as the period after which the compromise has taken place. The compromise period, where everything is withdrawn, bill is also withdrawn. The CJF by lot has withdrawn the bill. If your Lordship will see,
Yes, let us hear the other side.
Okay.
Yes.
just 107, if I can show, just for your Lordship, sir. Your Lordship will see this is withdrawn.
Yes, I have.
Withdrawn.
So if it's withdrawn, it's good for you.
But now, see the direction of the board of directors was communicated to us. That I will just
114.
115 minutes. May not kindly see. With reference to above, this is to inform you at page 115. This is what has been communicated. We don't know. We have asked for the copy. We have not been given of the board of directors minutes of the meeting. With it, lots of questions. Lecture 12, page 115. With reference to above, this is to inform you that the board of directors of APDCL in its board meeting dated 12/2/2024 has rejected the decision of the now. I'm in a precarious condition, your Lordship. Can you imagine?
Let us
And they
hear.
are going to disconnect my if I don't give on 30th, day after tomorrow.
That will not do.
Definitely will not do. You will not be getting the regular bill.
Now you tell me one thing.
My lord will kindly see their difficulty they have faced now is because they are the beneficiary of an illegal order. That committee, my lord, on its own, my lord will see the amount. In 2016, the final assessment amount was 1,71 lakh. Their CTPT meter was missing.
What else?
CTPT meter, that's a meter, my lord.
Ah.
Seal was missing. It was a tempered meter. It was a case of electricity theft also. Then, my lord, it was a bill of 1,71 lakhs was raised. One
In
interesting
16. In 16.
in 2016.
But the bills after that have been paid.
No, there is an interim order. So in the meantime,
No, but the regular bills will be paid.
legal bills were paid. So this amount, this claimed amount was never paid. So, my lord, in the meantime, there was a proceeding instituted before the Honorable Court regarding permissibility of instituting writ petition against this assessment order. Wherein this Honorable Court, up to the level of division bench, my lord, has held they have to rush to the appellate authority under section 127, not 126. At that moment, my lord, after the division bench order, since our offer for OTS was open, everybody rushed, my lord. Everybody rushed because otherwise they have to prefer an appeal under 127 and appellate to prefer their appeal, 50% is to be deposited. So everyone rushed to the OTS scheme. This person, my lord, they could reduce the amount, my lord will see 1 crore
I know,
71
that's what I was surprising, to nine lakhs.
9 lakhs only, my lord.
No, because of the period.
This is
I
not-
took your lordship.
They have a right of reply, my lord. They
Anyway,
will have a
listen,
right of reply, my lord. So, my lord will see any man of prudence, simple prudence, my lord, will come to know that 1 crore 70 lakh was reduced to 9 lakhs, my lord.
so I thought
And
you'll have,
they were-
you'll have a very big heart.
No, big heart of some corrupt officials of APDCL. It's not that we are not taking anything, doing anything against them, but if need be, we'll see that they are behind bars, my lord. Because these are public money, APDCL is striving for money, fund crunch is there, my lord. They have reduced from 1 crore 71 lakhs to 9 lakhs. So 1 crore 61 lakhs benefited by the petitioner. That is why, my lord, they suddenly rushed to this court and wanted to withdraw the writ petition. We said no, that was a decision of the empowered committee. Recommendation of the empowered committee. It is to be finalized by the BOD because my lord has seen the OTS scheme also says finally it has to be approved by the BOD. That's why the council for the APDCL made a submission that it is not yet completed. But no, they still wanted to withdraw. But something was there in their mind also, my lord, that they may be in trouble. That's why they took the liberty. That's why they took the liberty. And now, since this bill has been raised, they say that this is not good because we have accepted. Who has accepted? The original OTS scheme said that it has to be accepted by the BOD. Knowing fully well about the scheme, they participated. When the empowered committee, for reasons based known to those persons, accepted the scheme of which they are a beneficiary, my lord. Now they are saying it is not permissible. It is all accepted by the empowered committee. We cannot alter it. My lord will see. They have challenged the BOD decision by which their OTS was rejected by board of directors. That has been challenged, but probably it was not served to them. They have not annexed the copy.
But that's not the thing.
If we go somebody. First resolution, my lord. Final settlement of 3 numbers of applications under one-time settlement scheme. The board considered 3 numbers of settlement made by the empowered committee of OTS, so and so, namely MS Bridhi Iron, this is a petitioner, and Steel, MS Bridhi Iron and Steel, and Langri Tea Estate, and rejected the decisions of the empowered committee of OTSS 2022 and decided that original assessment bill of the full amount be restored and serviced to the respective consumers again, served to the respective consumers again. This is relevant, my lord. The board also decides to find out how the committee under OTSS 2022 arrived at its decision without having regard to the established norms and standards practice. The board also decided to form a committee to inquire into the facts which led to the empowered committee to take such decision. Right. Consequently, my lord, this empowered committee has been constituted to make an inquiry, cause an inquiry against this mischief of the empowered committee. As per resolution number, this is office order, my lord, as per resolution number 23, that is so and so, but to inquire into the facts regarding the resolution of the empowered committee OTS scheme 2022 against the application submitted by Bridhi Iron and Steel, a scrutiny committee is formed with the following official paper. It's a clear case of, my lord, collusion with the empowered committee, and 1 crore 71 lakhs will reduce to merely 9 lakhs, my lord. So let notice go, my lord, we'll produce the record.
Will issue notice, you produce the records.
We will not disconnect their electricity, my lord.
We'll record it. Heard Mr. D.K. Mishra, the senior counsel, assisted by Mr. S.K. Kejriwal. KS or SK? SK Kejriwal. Also heard, no, there is the petitioner's counsel submits that the the petitioner is aggrieved because the petitioner is aggrieved with the AP electricity bill dated 15/5/2024, by which the petitioner has been given the final assessment bill of rupees 3,97,98,050, which includes the earlier final assessment bill amounting to rupees 1,71,08,454, which was put to challenge in WPC 5067 of 2016. Next part. The petitioner's case is that a final assessment bill dated 26/8/2016 had been issued by the APTCL to the petitioner for an amount of rupees 1,71,08,454 on the allegation that there had been theft of electricity due to the seal of the electricity meter being broken. First up, the petitioner put the same to challenge by WPC 5067 of 2016. The APDSL initiated a one-time settlement scheme to reduce pending litigation, and the petitioner accordingly uploaded his application for one-time settlement on 26/4/2022 on the APDCL portal. The AP, the empowered committee which had been constituted to consider the various applications regarding the one-time settlement scheme, bracket, right? OTFCC, FF, OTFF, right? Wrote a letter dated 4/3/2023 to the petitioner stating that the petitioner's application had been deliberated upon and the empowered committee had resolved that the assessment bill of rupees 1,71,08,454 is withdrawn. So stop. Supplementary bill of rupees 9,72,477 was generated, which the petitioner was liable to pay. Subsequent to the above, the petitioner submitted an undertaking on 6/3/2023. The APDCL thereafter wrote a letter dated 16/3/2023. No, you're right. The Chief General Manager, bracket COM and EE, APDCL, thereafter wrote a letter dated 16/3/23 to the area manager, informing him that the petitioner had accepted the resolution of the OTSS empowered committee and paid settlement amount of rupees 9,72,477. The petitioner's counsel submit that in terms of reference of the empowered committee for OTSS, all the proposals of the empowered committee were to be placed before the APDCL Board of Directors by the Chief General Manager, bracket, COM and E, COM and E, right? For disposal on merits of each case. He submits that in view of the acceptance of the petitioner's application for OTSS by the empowered committee, the petitioner had withdrawn WPC number 5067 of 2016. However, after 1 year of settlement of the amount, the impugned bill dated 15/5/24 has been issued to the petitioner, which includes the earlier disputed amount of rupees 1,71,08,4. The learned counsel for the petitioner submits that the inner workings of the APDSA is not known to the petitioner, and once the APDSA has accepted the one-time settlement amount given by the petitioner, the matter should have been closed, and the same could not have been reopened in the manner sought to be done. Full stop. Next. Mr. P.N. Goswami, the learned additional AG, on the other hand, submit that the Board of Directors have considered the settlement offer made by the empowered committee and had rejected the application of the petition. He submits that in terms of the Board of Directors resolution dated 12/2/2024, it was decided to find out how the empowered committee under OTSS-2022 had arrived at its decision to make a settlement, to make a one-time settlement with the petitioner by forming a committee. To stop. Thereafter, in pursuance to the Board of Directors resolution dated 12/2/2024, an inquiry committee had been constituted by office order dated 22/04/2024, which was to scrutinize how the empowered committee took a decision for one-time settlement with the petition. He submits that the learned additional AG submits that he will produce all the records on the next date. All the records on the next date. And that no action will be taken
Will not disconnect the electricity.
and will not disconnect the electricity that is provided to the petition. Pusta. Next para you write. A perusal of the order dated 10/5/2023 passed by this court in WPC 5067/2016, by which the petitioner had withdrawn the earlier writ petition, shows that the application for one-time settlement made by the petitioner and the shows that the was to be considered by the board of directors of the APDC in terms of the terms of reference of the empowered committee for OTSS Act 2022. In terms of clause 8 of the terms of reference, of empowered committee for one OTSS Act 2022. This is the matter after we to enable the additional AG to produce the report.
Your lordship will give some date, my lord.
Notice is not required. Notice required. We issue notice. We'll issue notice.
Issue of
Yes, I issue notice. Returnable in 2 weeks. With the KP Patak, except notice on behalf of the APDC. This is the matter. Within the 14, they've already put something. 13?
20th.
20. 20.
20th. And deeply out.
Items 6, 7, and 8, they are same methods.
So,
So Lord, we have taken steps on this.
when
Today we have taken.
you're taking steps today, what is your name?
Lordship AK Chopi appearing on behalf of
AK Chopin. CHOPI.
HI.
Chopi. Learned counsel for the petitioner. Petitioner submits that steps have been taken for service of notice upon the respondent number 5.
124. Water Resources Department.
Miss,
Payload.
who is 5?
124.
No, who is 5?
5. Lordship, it's Manager Marketing Division. Manager Marketing Division. Assam Small Industries Development Corporation Limited.
Why are they involved?
Yes,
Why is the manager marketing division, this Assam small scale, why are they why are they made parties here? Otherwise, this could have been disposed of in the same manner. Tell me what is their requirement? I mean, what is the grievance against them?
Lordship, a work order dated 18/5/2012 was issued by the Manager Marketing.
Where is that page?
Lordship, page number 6. There are 4.
Page 6. Para 4. Okay, I don't. There by the manager marketing, Assam Small Scale Industries. If they had issued the work order, then why is the Water Resource Department a party? What is the connection between the Water Resource Department And this respondent number 5.
Lordship, probably because they are also a party to the,
I know they are a party. You made them a party. Why? I'm asking you why you made them a party. Where is your senior?
at least on that.
He's on late. Tell him to come. Okay. Let him come. Let us clarify. Don't write to him. Sit there.
Like-
Made use of. My lord, sincere apology for not being able to take step in person to the order which was passed on the last occasion. Today morning, my clerk told me that he has taken steps, my lord. So I have the proof of taking steps on the private respondent number 8, which he
Yes, you are for whom?
My lord, I am for
they are for a private respondent.
private respondent.
Number?
Number, my lord, 6 and 7.
My lord,
So your challenge is against whom?
my lord, the brief background is what, my lord, your lordship, if remembers, my lord, an order was passed for directing the respondents to settle the fishery on a permanent basis by inviting NIT.
Ah.
That was a Sipsagar based fishery, Brahmaputra Part 2, my lord, in which clear direction was given by my lord that if till you take a fresh call on issuing NIT, no, my lord, ad hoc mechanism would be adopted and no daily basis would be, my lord, undertaken by the government. In spite of that, my lord, clear directions, my lord, what they did, they again introduced, my lord, this chronic, my lord, mechanism of giving settlement on the daily basis.
Then why don't you file a contempt?
Yes, my lord. So what we did, my lord, we just approached it because the arrangement which was made ad hoc has to be put to stay somewhere or the other. So we immediately approached by filing this current petition. Then we were told on that day an order was passed by the state government taking away all the ad hoc mechanism, my lord. This is the order. Now, my lord, how far this order has been implemented?
That is something we don't know.
Yes,
We are not a policeman to,
Yes, my lord.
to run after each and every
Yes,
complaint.
my lord. Yes, my lord. Yes. So, my lord, then this court was pleased to issue notice and the council appearing for the government had produced this order saying that they have put a stall on this ad hoc mechanism and they are going to very soon again issue an IT. In between, the order which my lord has passed was put to challenge before the division bench. And then that order also was set aside. I mean to say, my lord, the appeal was dismissed and this is a recent order. And in that last order, my lord, there has been a reflection relating to, my lord, I should appraise this court regarding what was the status of
Where is the order of the single judge?
yes, my lord.
Page?
Your lordship order starts from page 611. 67 is start, my lord, relevant part. And the operative part is at page 72, my lord.
This grievance is being made, Lordship.
Because of this order. Huh? His grievance has been
Yes, Lordship.
addressed by this order.
Lordship, by the,
12th April,
yes, Lordship, yes,
12th April.
Lordship. So Lordship, I'm praying for disposing of this flight.
Yes, there's nothing remains.
Nothing in
This order,
Order nothing, nothing remains, but it's all hiccup which we are having this anticipation.
apprehension.
Arrangement which was made in respect of giving this fishery on a daily basis to the private respondent, they haven't taken any particular order or action against that incumbent, even pursuant to these developments which have taken place.
No, but where is the order allowing them to go on, to do business on a daily basis? Where is that order? Do you have it here? Is it-
Yes, that is the order we have put to challenge.
Where is that?
Yes. 84.
Page 84.
Annexure 3.
Yeah.
Page 84.
This order is being superseded by this order, Lordship, 12-4 order.
84.
Where does it say superseded?
It doesn't say. That is what I'm saying, man.
But because we have taken a decision to go for daily basis, Lordship, so automatically it will supersede. It will go, this will not remain, Lordship. Lordship can, that's not my statement also, it will not remain, Lordship. Daily
I'm
basis
not
will
on
not
it.
remain.
Lordship can very well dispose of the case, man.
But
I'm
we
not
are
on that.
in-
But
the
only
Lordship
thing
had
is some assurance from
Nothing,
them
if
that
anything
an
happens,
NIT should
past,
come forward.
Lordship passed.
Man,
Nothing
an
will
NIT should come forth.
Huh?
My lord, an NIT should be floated as soon as possible, pursuant to my lord's order.
Why are you not filing, why are you not making the NIT?
Lordship, we have to issue, the DC is supposed to issue the NIT, Lordship. I think DC has already processed it, Lordship. Due to election process, Lordship.
Probably due to
maybe,
election,
maybe.
that is one.
Strong room, Lordship, there is some responsibility also. After that, everything will be clear now. Past is past, Lordship, nothing will happen. In daily basis, Lordship.
The problem is the past becomes the present for you.
It continues, my lord.
But
It continues.
here, Lordship, if anything, I can assure you, Lord, nothing will happen, Lordship, as of now. After 12 or 4, 12 April.
Where is the order, earlier order that I found?
My lord, order must start from page 65, relevant portion 67, my lord.
And
And your Brahmaputra Part 2
I
fishery.
am Brahmaputra part 2, my lord. That's the same feature which is in question before this court now.
just keep this from the people.
There's nothing here. It is already.
Something, but
There's no instructions, Mr. Council. What instructions would you get?
I was running the fishery.
You're running the fishery.
They
Yes,
cannot.
my
Huh?
lord. Yes, we are running the fishery.
You're running the fishery.
That is exactly what I said, my lord.
Yeah.
That
It
is
is
exactly-
running. It is against our order, Lord. I'm not forced to this particular order.
Then automatically my lord can take up to go to contempt, my lord.
Yes, I'll issue contempt.
Yes, my lord.
Page number 84.
Yeah, you're running the fishery. I'll do it. I'll record your statement. No. You're very clear. If you're running the fishery, I will record your statement.
Yes, sir.
I was running for the daily basis as per this particular order. I have to procure the instruction, Madam. Whether I'm
No, that is, no, it's okay. I
That
thought,
is-
there's no, the contempt will not be against you. The contempt will be against the officials. Don't worry.
at least a week time so that I can procure the instruction.
I will hear you, Mr. Council. I've heard you. It's not that you said 1,000 times that I have to, you're going to convince me otherwise. Who are you out here?
I am one of the prospective bidders who, my lord, was the.
No, you are a respondent number.
I'm respondent number, my lord, 6 and 7, my lord.
It is there.
If I may take my lord to page number 85. For a moment.
Yes.
Third last paragraph.
Hmm.
Accordingly, government is pleased to allow SS so and so to run fishery on daily basis at 920 per day from the date of handing over possession of the fishery until further on. This is the order on the basis of which I was, my lord, running it on a daily basis. As
Very good.
as to now, my lord, I do not have any instruction what my position is.
No, it's good. I just want to know if this order is subsequent to my order. If it is subsequent to my order, then contempt is made up.
Yeah.
Probably made up.
I will not protect him. They have to accept. We are from the government lordship, from the government, from the department, we are very strict that daily basis should be over and out.
22, 24. And this is 15-3. Now, what was the order passed by the single bench? Let us see.
Yes, Bharat. At page 72, relevant portion starts from paragraph number 14, madam. Sixteen is the operative part.
Oh, okay, because I have only mentioned respondent number 8.
And
No, I have not.
yes, my lord, your lordship has mentioned response number 8. It will not be settled. Very conveniently, the whole idea before this court was to avoid daily basis. What was pleaded before your lordship on the earlier date. Now, my lord, to circumvent that situation, conveniently they picked up another person, and I have alleged in the current petition that they are all related. Now, this person is not a
No,
person.
no, anyway.
That is a different thing. I'm not pressing on that.
No, why
I
am
was not a party in the Of course not. What that is why currently I have alleged it's a different person, man.
now, Mr. Counsel, Mr. Sharma? This page 84. Okay. Why is it not being implemented? Why is this not? Why is this order not cancelled?
It is cancelled, Lord,
Where?
by this order, Lord. By this,
I think we will ask this officer to appear before us.
Yes, sir.
Let him clarify. Additional secretary. Has it been cancelled? Where is the cancellation of?
Lordship, by this 12-4 order, it covers, Lord. By 12-4 order, this order is also covered, Lord. Lordship can vote for this also. Make with the 12-4-2024 order, Lord.
Yes, let us see.
That's it. And I'm reading. Should I read the operative part? Or not? Under the circumstances, government, after careful consideration of all materials, including the observation direction and instant utility, decided that
Okay,
on
right.
such daily basis temporary running.
We'll dispose of. Heard, Mr. H. Buragoy, Learned Counsel for the petition. Also heard Mr. P. Sharma appearing for the Fisheries Department. And Mr.
R. Central.
R.
R. Central.
appearing for the respondent number 6 and 7. The petitioner has challenged the order dated 15/3/2024, bearing memo number ECF number full stop E-285-340-121, issued by the respondent number 3, by which the authorities have settled the Brahmaputra Part 2 fishery in the district of Sibsagar in favor of the respondent numbers 6 and 7 on a daily basis at the rate of rupees 920 per day. Till regular settlement of the fishery is made through a tender process. Full stop. Next part. The petitioner's counsel submits that this court in its order dated 20/02/2024 passed in WPC number 2764/2022 had directed that the settlement of the Brahmaputra Part 2 fishery in Sibsagar district should be made after issuance of a fresh NIT and the settlement of the said fishery on a daily basis with the respondent number 8 in WPC number 2764/2022 should not be made till final settlement on the basis of an NIT was made by the state authority. Next paragraph. The petitioner's cause is submit that the order dated 20/02/24 passed in WPC 2764/2022 was put to challenge by
Private responsibility.
by the by the respondent number 8 by WA 134/2024. However, WA 134/2024 was dismissed by the division bench by order dated 15/5/2024. The petitioner's counsel submit that despite the direction passed by this court directing the state respondents to issue a fresh NIT and not to settle the fishery on a daily basis till regular settlement was made through an NIT, the additional secretary to the government of Assam by order dated 15/3/2024 had settled the fishery on a daily basis with the respondents number 6 and 7 at the rate of rupees 920 per day. He submits that the impugned order dated 15/3/2024 flies in the face of the orders passed by the single bench and the division bench of this court. And as such, the same to be set aside. So stop. Next paragraph. Mr. P. Sharma, the learned counsel for the Fishery Department, submit that the order dated 15/3/2024, by which the respondents number 6 and 7 have been allowed to operate the Brahmaputra Part 2 fishery in Sibsagar district has been superseded by the order dated 12/4/2024 passed by the Commissioner Secretary to the Government of Assam Fishery Department. Combined as much as no settlement of the fishery, no settlement of any 60% category of government fishery will be allowed to run after 11/5/2024 in terms of the said order dated 12/4/2020. He accordingly submits that the respondent number 6 and 7 will not be allowed, could not have run the fishery on a daily basis subsequent to the order dated 12/4/2020. Next paragraph. Mr. R. Pelto, learned counsel for the response number 6 and 7, submit that the respondent number 6 and 7 were running the fishery on a daily basis on the strength of the order dated 15/3/2024 passed by the additional secretary of the government of Assam, Fishery Department. He, however, does not know if the respondents number 6 and 7 are running the fishery any longer subsequent to the order dated 12/4/2024 issued by the Fishery Department. I have heard the learned causes for the party. The order dated 20/02/2024 passed in WPC 2764/2022 had categorically directed the Fishery Department to issue a fresh NIT for settlement of the said fishery, and that the said fishery should not be settled on a daily basis with the respondent number 8 till final settlement of the fishery had been made pursuant to the NIT to be published by the Fishery Department. The said order has been upheld by the division bench of this court by in WA number 134/2020. Interestingly, the additional secretary to the government of Assam Fishery Department had settled the fishery with the respondent number 6 and 7 on a daily basis. Inasmuch as this court had directed that the settlement of the fishery on a daily basis should not be made with the respondent number 8 in WPC 2764/22. The import of the direction passed in the order dated 20/02/24 in WPC 2764/2022 was that the fishery should not be settled with any person on a daily basis. So, however, as the respondent number 8 was running the fishery on a daily basis, it was categorically pointed out that the respondent number 8 should not be allowed to run the fishery on a daily basis. Prima facie, it appears that the additional secretary to the government of Assam Fishery Department had been circumventing the order of this court in WPC number 2764/2020, which is not appreciated and could have been sternly acted upon by the. However, in view of the order dated 12/4/2024 issued by the Commissioner Secretary to the Government of Assam Fishery Department, which has clarified that which has clarified that none of the 60% category of government fisheries will be allowed to run on a daily basis after 11/5/2024. What have I said? How? This court is overlooking the order dated, the impugned order dated 15/3/2020, inasmuch as the same has been superseded by the order dated 12/4/2024, issued by the Commissioner Secretary to Government of Assam Fishery Department. The the Fishery Department are directed to strictly comply with the order dated 9/4/2024, passed in WPC 1911/2024. No, comply with the order dated 20/02/24, passed in WPC 2764/20, and the order dated 12/4/2024, issued by the Commissioner and Secretary to the Government of Assam Fishery Department. The Fishery Department shall cause a verification to be made with respect to whether the respondent number, whether the private respondents are still running the Brahmaputra Part 2 fishery in Saka district. And if and if the same is still being run on a daily basis, the respondent shall put a stop to it immediately. The writ petition is accordingly disposed of.
I'm highly applied.
Greatly applied. You just say before that, the order dated 12/4/2024, passed by the Commissioner Secretary to the Government of Assam Fishery Department, is made a part of the record and marked as Annexure X.
I'm deeply obliged, highly obliged.
All this.
Lordship, I have two full argument to make. Lordship, after completion of the work order, Lordship, I have raised bill, my lord, they have, come to conclusion the matter is disputed. So they,
Matter disputed.
yes. Although I have duly completed and my case is covered under the terms and condition of MIT. And according to their clause, your lordship, if the architect settles the amount, verifies the amount, it will be final and binding on the bank.
What?
Duly appointed architect of the bank. If the verifies the bill and settles the amount, then it will be binding on them. But they have come to the conclusion that I have raised certain amount here and there, and that matter is disputed amount. If your lordship entertains it, I have no objection because they have come up with a plea, the disputed question of facts, or it will not lie. It's up to your lordship. And if your lordship comes to a conclusion that it will not lie, I have an alternative lordship fair to make, your lordship. I have deposited certain amount, earnest amount of money, and certain security deposit and all, and that may be released to me after due verification, my lord. Retention money, earnest money, and admitted outstanding dues, along with interest, because it's a bank, your lordship. I have deposited certain amounts in the year 2012 itself. They have retained my amount for a period of 12 years or so. Lordship, my limited prayer is that the bank will verify the amount and release the same. And regarding the disputed question, I'll avail the appropriate form.
Yes, Mr. Datta. Very fair, sir. Okay, right.
Lordship, only one submission to make that the limitation will not lie. Under section 30. There is
Your lordship can observe.
because 3 years because I mean, 3 years.
That you can always go to the civil court. Section 14 of the
Yes.
Limitation Act is there.
That may be observed.
No, you go there, no. We say as per law, that's how you go as per law. You cannot.
No, wrong.
be-
They may come up
No,
wrong
then,
for they may say this situation of fact. Lordship, since I have approached this honorable court, it would have been This even more, that observation.
One of the exercise of, my lord.
Then you can always go. You see, when we have passed an order,
Fine.
the order itself will say that the admitted amount should be paid and the disputed amount they can go. So that will take care of that limitation. If it was Toto rejected fully, it might have a different connotation, but not when it's partly allowed.
And on that technical part, possibly, my lord, bank is not going to.
Bank, even if bank does, might not have much of problem.
Lordship, whatever is due, I have stated in my affidavit reply.
No, anyway, we do not know because how much they have admitted, we do not know.
My lord.
Then-
No, amount, not amount. Earnest money, retention money. security. If any, my lord, along with interest, I'll be claiming interest.
No. Not another thing. Retention money and security. deposit.
Earnest money.
Earnest money.
The lordship will find in their affidavit itself at page 8. Paragraph 11.
This is on basis of some contracts you have done.
Yes,
NIT, my lord, I've completed the work. The architect verified it, again re-verified. Now they have come out with the plea, there's a deviation.
paragraph 11. Your lordship.
So you are claiming total amount of 2,30,000.
Seven,
That's all.
and along with it,
That's the
as per
matter.
the interest release.
Lord, so for disputed parties, the lordship can receive A, 1,13,440, that is the retention money. And then B, rupees 30,000 earnest money. Possibly they are entitled this to pay.
Then
So far, C is concerned, 87,278, that is my lord disputed one.
right. Right, Mr. B. Then it's senior counsel for the petitioner. As well as Mr. F. Datta, then it's senior counsel for the respondent bank. The petitioner has paid for payment of his contractual dues amounting to rupees 2,30,71. The petitioner's counsel submits this paragraph that out of the total contractual dues amounting to rupees 18,30,386, the petitioner has received rupees
20,40,000.
Now, how can it be? Your calculation is wrong, madam.
Not
Acha, this retention money and this is not there.
Is not there. Admitted amount is 17,43,100 each, that we have paid.
Huh.
Now they're asking for.
But you see, when you minus 17 lakh from 18 lakh, only not even 1 lakh remains. But out here she's claiming 2 lakh.
No, that's my lord inflated one. 2,30,000 is inflated one. My lord,
No, but anyway, but it doesn't make sense. Para 11.
Lordship, may I,
Yes.
may I submit? My case may be recorded, let them verify. Even if
No, but your case, when it's recorded also straight away, it doesn't seem plausible.
out of 18 lakhs, 30,386.
7 lakh 43 has been given. So that means less than 1 lakh remains.
Then retention money, 113,440. Earnest money, 30,000.
Okay. So this is not there.
Uh,
Okay.
87 is
So only 87 remains actually.
87 is disputed part. They are possibly entitled to retention money.
Yes.
13,000.
Okay, what have I said? Seventeen, 43, 108. Leaving a balance of rupees 87, 278. Full stop. Besides the balance amount of rupees 87, 278, the petitioner is also entitled to receive an amount of rupees 1,13,440 as retention money and 30,000 earnest money. Full stop. The petitioner's counsel thus prays that a direction should be issued to the respondent to pay the admitted amount and to give her liberty to approach the civil court to make a claim for the disputed amount. Uttam. Next para, Mr. S. Datta, the learned senior counsel for the respondent bank, submits that he has got no objection with the prayer made by the counsel for the petition. Uttam. He submits that the respondent bank shall verify the amount payable to the petitioner and pay the admitted amount to the petitioner. It can pay the amount. Uttam. And next para, in view of the consent of the parties, comma, the respondent bank is directed to verify the amount payable to the petitioner within a period of, and pay the petitioner the admitted amount within a period of 6 weeks. 6 weeks from the date of receipt of a copy of this fund. Good stuff. The petitioner the petitioner is also given the liberty to approach the civil court with respect to the disputed amount.
To the amount of rupees 87.
That's
No, I'm not saying,
mentioned.
I'm not saying.
Lordship,
You might dispute that 30,000 also, I don't know.
Lordship, my prayer is to pay interest. My prayer be recorded.
Okay. Acha, in the earlier part, the pay so along with interest. Interest portion, no, no.
And if you, Lordship, I'll appropriate, I'll
You
approve
go,
that.
Acha, what about the
They are bank, your
interest? You
Lordship.
give some bank interest,
Lordship.
Your interest under the terms of the contract is not there.
but earnest money you've kept for so long.
If it is in the terms of, my lord, contract, in that case, it's okay, but if it is beyond the terms, my lord, I don't think.
They are violating their own terms, my lord. Let us not go into the merits of the case. Because
Acha, whatever I said, at the last part, whatever I said, within a period of, shall pay the admitted amount, and shall. No, I shall pay the admitted amount along with interest. Along with interest, comma, as permitted. As
Yes,
permitted, comma, within a period of,
As permitted in terms of their contract.
not
as
us.
permitted, so this is as permitted.
Lordship,
So so that, so he can take up the stand before the
yes.
civil court.
So the next case is also.
The writ petition is accordingly disposed of. Then the next case also out here,
Before,
just a minute, let us go to the, out here,
Your lordship,
amount is 20,97,587.50. And payment is 16,34,634.
my lord, 18,61,660.
Where are you reading?
Lordship may take up the reply affidavit, my reply affidavit.
That page 8,
Para 11.
para 11, yes.
Para 11 is 20,97,587.50. And okay, amount paid is 18,61,666.
Correct.
Okay, and then the remaining portion is
1,65,366.
2,35,919.50.
Is the disputed.
And then the retention money is 165,366. And earnest money is 42,000.
Yes.
Keep your
Obliged.
long pending matter, my lord, how to fix it.
13 and 14.
It is a lot. Matter is it to the tender of Sen Mahal for the period of 2017 and 19.
Tender dated
Tender dated 12/1/2017 for the
12/1/17
17 and
for which period?
2017 to 2019.
17 to 2019. Has it become infractuous?
Not
Okay, right. Miss
Ember,
M. Bora, Leonard counsel for the petition and submit that both the writ petitions have become infructuous. Mr. R. Gogoi appears for the respondent Forest Department. In view of the submission, in view of the uh, writ petition becoming infructuous, the same is dismissed as infructuous.
but however, petitioner may be allowed to file representation if any,
For what?
for that he has deposited the 7 fees money against which no Alan 20% of the future. If any less.
Ah.
2 lakh.
Okay, right. The petitioner also given the liberty to file a representation to the authorities for,
For a division for subsidiary purpose.
Huh?
Division for subsidiary.
DFO.
DFO lot.
to the concerned authority for release of any
This month.
for any kissed money, for return of any kissed money that the petitioner may be entitled to.
Okay.
Highly open.
My lord, in this case, the state item number 15 and 16 mention. Yeah, item number 15 and 16 was as per Rocky Soda on 11/2024 was. We have communicated with the supplemental and today my brother says that he will appear.
Mr. R. Bora appear, submit that he will be filing a Vakalatnama on behalf of respondents number 4 and 5. Already filed. Okay, submit that he has filed Vakalatnama on behalf of respondent number 4 and 5 and prays for 2 weeks time to file affidavit in the police. List the matter of 2 weeks.
My lord, the interim order
Interim order to continue till the next day.
may have a fixed date. My lord.
Yes.
Well, after the, after that. Right. But the matter pertains to non-payment of contractor
Yes, well, the council,
material. Pending amount.
is there, where is the admission?
Mission, I think your lordship will, find page 20 here.
Huh?
Page 20, your lordship, they have given a reply to my. Part payment for office, authority.
Yeah, Miss Loda is there.
You are paying for water department. Then wait.
Should be to-
Here's the second copy, second copy. Go to page 20.
Lordship, 2 weeks time be granted to.
Let her, Miss Eloda, appearing on behalf of the Water Resource Department. shall obtain instructions with regard to the admission made by the executive engineer, filter water resource division in his letter dated 10/6/2020, bracket page 20. Huh? This is a matter of 2 weeks.
I'll
Well, the petitioner has made inquiries and has learned that there is money in the bank account of the Madahi Development Council, but they are planning to divert the money to some other use. I have also obtained budget provision statements for the year, for the current financial year as also for the previous.
Mr. Dar, have you given the 3 lakhs?
My lord, that is the problem, my lord. They are doing everything, but they're not coming to collect this check. That is the problem. This is the third time, my lord, I am.
You take the check.
Full payment, madam.
Huh?
They can make the full payment.
At least take part of it. One bird in hand is better than 2 in the bush.
My lord, we never said that we are not going to pay it, my lord. This is an interim thing, my lord, because of, my lord, this budget.
I do not know why you don't want to take it.
Madam, then they will calculate interest from,
What interest?
So what? What interest?
My lord,
We are
not a civil
saving
suit,
This
just
is this. Then I'm dismissing this. You go to the civil suit and file.
let them
it.
go to civil court, my lord. Let them.
If you're not
If they
accepting
want
this money,
money, then they will get.
what do you mean
Yes, my lord.
calculating interest?
My lord,
You're not accepting the check. What is this?
third occasion, my lord, I am here with this check, my lord.
You take the check. Or you submit it before the registry then. If they don't want to take it, you don't want to take it. I'll record your submit. Third means
will exercise take
Huh?
further payment.
actually further payment will be made.
We,
We are not disposing of the writ petition.
They will.
Who will accept? You or it's to the client, correct?
it is in the name of the client.
It's a cross check, correct? So should we put it in the registry or well? Huh? Registry, better.
I will
Submit it to the registry.
happen to I will pass on direction. I will put it today.
Miss, what is your name?
And
And Ahmed appears for the petition. Mr. Arda appears for the Tribal Affairs bracket plain department and submits that he has got the check for payment of rupees 3 lakhs for the third time, which is not being accepted by the petitioner. Mr. Ardhar is accordingly allowed to submit the check before the registry, who shall thereafter furnish the same to the petitioner on proper identification. Yes, what about the rest of the money?
My lord may dispose of the matter of the direction.
No, I'm not disposing.
3 months, my lord.
I'm not disposing. When you can you give the next?
My lord, my lord, in 3 months we will pay. That is-
You may pay 3 months, but why don't you pay a small amount now by next month at least?
My lord, it's not about small amount. We'll pay the entire amount. That is, there is no dispute. We are not disputing the money.
Right, Mr. Ardhar, submit that the respondent shall pay the balance amount of rupees 9,58,666 within 3 months from today. However, this court is of the view that some amount should also be paid within 1 month from today. Accordingly, leave this matter on. Today is 29. Leave this matter on 26 June. Deputy. Came in the morning. I don't know why. I do not know why the petitioner's counsel seeks an adjournment when I told him that the respondents have admitted but he wants to adjourn. They've admitted the amount. I said, I'm going to allow your petition, but he still wants adjournment.
Mr. Pilot, he is waiting for some actual instruction from the client. So today, he will- Why CGP is here?
Where?
And for total admissible amount also which is there, 30,32,
Where? Page?
page 60, internal page 60.
Yes. For admissible amount 30,32,366, correct?
6 lost it.
30, 30, 30. So this is, but why is it 2%? Why are you deducting 2%?
That part was it. The picture of-
Why are you deducting 2%?
That is as per negotiation. In other day loss, 10% also negotiated. That matter was it. Like after inspection. After negotiation.
Okay, after negotiation.
After negotiation. Other day loss, it was at 10% of the, in one matter. That matter, my loss is like after inspection. The actual amount after negotiation of 10%. Because it is not there, give another chance to them. Otherwise, looking at it, I am not.
I don't understand why they want to adjourn.
Lost it.
Everybody wants a favorable order. He doesn't want a favorable order. But the issue is not the council. The issue is the petitioner.
Even not say,
So I'll dispose of if he's not there. Or he can go in appeal.
Madam, kindly page,
I'll allow the writ petition. He can appeal. No problem.
kindly page 62 loss.
62.
62 regarding 2%, he has agreed. He has self declaration by the petitioner. Page 62 lordship. I have agreed last 3 lines lordship.
Yes.
I have agreed to cut 2% of total amount for one-time settlement. For
Okay, right.
lordship.
No one appears for the petitioner. Though though Mr. M. Pandit had appeared for the petitioner at 10:15 a.m., asking for adjournment of this case. This court had, however, informed the petitioner that the matter was being disposed of as the claim of the petitioner had been admitted by the state respondent. Next up, Mr. K. Gogoi appearing for all the respondents submits that the hiring charges of rupees 30, hiring charges of vehicles amounting to rupees 30,32,66366 is admitted by the respondent, as can be seen from para 7 of the affidavit in opposition filed by the respondent number 4.
And my lord,
Full stop. He, however, submits that out of the admitted amount of 30,32,366, 2% of the total amount is to be deducted
is closely amounting.
on the basis of amounting to rupees
Closely, it is page 63, my lord. May I kindly
Page?
Page 63, my lord. Page 60, lord.
amounting to rupees
29,33,504. It is also remarks column is there also. After the negotiation with the petitioner, the bill has been prepared in deduction of 2% from the total amount.
How much is it?
What's your remarks from law?
Amount is not given. There's only the 2% is paid. There is no amount.
Amount claimed also.
Amount payment is first. Ah. So it will be minus that.
Minus that.
Huh. Wait, huh?
It was after negotiation.
Just a minute. I will give you. 2, 6, 2, 2. So amounting to rupees 98,86. 98,86. Correct. 2% is 98.2. He submits that the respondents are accordingly liable to pay to the petitioner an amount of rupees 29,33,504. So after negotiations were made and settlement was arrived at between the petitioner and the respondent. So, Mr. I have heard the counsel for the respondent and perused the pleadings. Next para. The case of the petitioner is that she is a registered owner of a vehicle bearing registration number AS-16. This is para 2 of the order dated 18/10/2020. Next para. The affidavit of the respondent number 4, who is the Superintendent of Police, Pokraja, is to the effect that the respondents are liable to pay rupees 30,32,366 to the petitioner. However, as the respondent has no authority, however, after negotiations were made with the petitioner, deduction of 2% is to be made from the total admitted amount. And in this regard, the self-declaration made by the petitioner, which is at Annexure A of the affidavit filed by the respondent number 4, shows that he has agreed to deduction of 2% from the total claimed amount. Next para. The original claim of the petitioner was 32,360. However, after deducting 2% from the total amount, the amount payable to the petitioner is rupees 29,33,504.
Okay, under the remarks column, it is under process in the lottery, Assam Police Headquarters lottery.
And I'm going to write. The affidavit of the respondent number 4 further submits that as the respondent number 4 has no authority to sanction the hiring charges, to sanction the amount claimed as higher charges, the bills were forwarded to the Assam Police Headquarters, Ulubari, for according necessary sanction and release of funds. in view of the admission made by the respondent that they are liable to pay to the petitioner rupees 29,33,504. The respondents are directed to release the said admitted the said negotiated amount of rupees 29,33,504 within a period of
at least 3 months.
3 months from the date of receipt of a copy of this order. The writ petition is accordingly disposed. Congratulations. Yes,
It is a restricted lordship. Schedule 1 lordship, category 160 law. That
Huh?
particular amount. The district administration, like, the authority is the beyond the jurisdiction. Roman 50.
38. 0.38.
138 lordship is a lordship, so it is made lordship in the US lordship. Yeah.
All these
Otherwise-
pictures are all usually made.
Otherwise,
Yeah.
it is a originated from 0.38 lordship.
Huh?
0.38 lordship.
There is not a question of origin made in Pakistan or India or America. It's a question of the whether it's a restricted board. That's all.
Lordship. The restricted one lordship.
What to do, Mr. Constable?
Lordship, we're challenging the order dated 1/11/2019. So Lordship, one chance may be given, file the return
111, page
2019. It is at your Lordship.
Lordship, page 52 lordship. Last page of the report. Annexure 13 lordship, page 52.
So did you buy the 0.38 after getting the license or what? Let us see your license.
License is at your Lordship 44, annexure A.
It starts from 42.
Lordship, it is earlier there, it is a lordship, as per the, this is in his father's name lordship, it is in. And it is transferred to his name after the.
But let us see, was it a 0.38 that time?
0.3 lordship, 0.3.
Huh?
0.3.
So it was in his father's name.
Father.
Then?
And father, after father's death, it was transferred to him.
So? Anyway, you plain instructive. Your unified reply. Mr.
KJ Hazari.
A.J. Hazarika. It's from his father's time.
Lordship.
It's from his father's time.
It's
And in
father's
it,
time,
supposing, instead of that, you should allow him to make an application also before the concerned authority who has got power to allow things. Why should you take it away? It's in his family for since his father's time.
The admitted package is in father's time. For the original part was done recently, and it was done by the.
Renewal. Prior to renewal, it was transferred to him. So prior to transfer, it was in his father's name. It has been there for
It is since 1974. It is admitted fact. Otherwise, the renewal part we cannot look. That's because it is a restricted it is from the central government.
that is why instead of asking him to deposit, you should allow him to make an application before the concerned authority. There was no reasonable,
Huh?
there was no reason given out why the license was not kept
Correct.
by the.
I have only brought it out anyway.
Otherwise, Lossi, it is on the basis of that restriction part, Lossi, we have issued it, Lossi, because we have no authority. Without the authority, Lossi, we allow him to, Lossi, carry a weapon, Lossi.
Huh?
Without the authority, Lossi. We give a license to carry it, Lossi, or renew it to carry it, Lossi. This, Lossi, beyond the jurisdiction of the state authority.
Where does it say that 0.38 can be given only by the central government?
Central government is a restriction.
Where does it say?
What, Lossi, in our affidavit, we have stated, Lossi.
You see, earlier times, I'll tell you, during the World War II and all, you see, there's a lot of pistols and all. Prohibited bores were used and lot of permits were given. 9mm pistols. All the, you think all these army officers, they don't have, they have. Permissions are given. So, and now suddenly you have become strict.
Then we lost it.
So, but then he's been having it since father's time. You should think of,
But the license you also lost it.
no, he should be allowed to approach the proper authorities for issuing a proper license.
We have not a particular.
Now, who is the proper authority?
From the central government.
Where does it say that?
Central government also have to take authority as per rule, probably rule 6 also.
Let us see.
Rule 6 is the authority of the central government.
Let us see rule 6.
Rule 6. Rule 6, not in the middle portion of the book for everyone. And our affidavit also, we have says that the license was already cancelled on 11/11/2019 law. And that order was not put to the next law.
Anyway, whatever it is, Vista, KJ, Hazarika is granted 6 weeks time to update, to file affidavit in reply. Affidavit, this is the matter. Pleasure.
This is for non-payment of the contractual bills, notices the issue. Instead, they must file a data for instruction.
Yes. Who is appearing for the other side? PWD. Can you call them? I said, can you call them? Who is the counsel? Gogoi, Mr. Gogoi. $24.25. No, different.
We have received instruction also.
Huh?
We have received instruction.
Okay, to what effect? What is the instruction? What does the instruction say?
I think the refund of.
Refund? What refund?
Regarding the refund, VAT deducted at
Refund of?
VAT deducted at 5% point amount
Yes.
in line by
So what about it? And when can you file your affidavit?
2 weeks time.
Why? Instructions are there. Miss
Which is the
Toshi Senla, Learned Counsel for the
enrollment.
Handloom and Textiles Department. Submits that affidavit, submits that parawise comments have been received. And she'll be filing affidavit in a position within 3 weeks.
Yes.
This is a matter after 3 weeks. Toshi Senla appearing on behalf of whom?
It's only 1 and 2.
No, your senior.
Aadhaar or
Aadhar. Remember, Aadhar. PNRD. Yes,
Take time to filing it.
yes, madam, what to do?
wetland.
Okay. Ms. N. Bora, Learned Counsel for the respondents number 26 and Mr. G. Bakalian for 1, 4, and 5 are granted a further 3 weeks time to file affidavit. This is a matter of 3 weeks.
Lordship, due to some personal difficulties, the aide someone could not appear. Kindly grant.
So has the contract been awarded?
That
Then what have you come, any instructions? Have you received any instructions?
all of it. That regard,
Huh?
that to that regard, no instruction.
Why? Then no. What have they told you? Nothing. Have you asked for anything? No. And what have you come here? Just to show your face? Your plain instructions as to whether the contract has been awarded. What is the status? Okay. Our judgment prayer has been made on behalf of Mr. A. Chamwa, Learned Counsel for the petition. Mr.
Nisha,
T. Sharma appearing for
water take.
Water Resource Department shall obtain instructions with regard to whether the contract has been awarded. This is the matter after the week. Simple matter.
May please lordship. Lordship, in this matter, we filed an affidavit and reply along upon the affidavit in opposition filed by respondent number 4. And this has not been tagged in the post report. So kindly grant us 1 week time,
Who
1 week time,
or what?
for, we have filed one affidavit in reply and it has not been tagged in the post.
Not recorded of the reply.
Okay, right, Miss.
You, Nanda.
Nanda submits that the affidavit in reply filed by the petitioner is not on record. We just need to place the same on record. List the matter after a week.
Lordship, one more query is there. Let the matter be listed with another matter, a similar matter, WPC 1585 of
Why?
2024.
Is it the same?
Yes, Lordship.
How can it be the same?
Separate, sir.
It's different. It's not correlated. Maybe similar kind of case.
All right.
Okay, list the matter along with
WPC 1585 of
1585 of
2024.
24. Huh?
Right.
32 for order.
Please, Your Lordship. Your Lordship, this is the forest royalty matter, Your Lordship, and as per the last order, they are supposed to file the affidavit regarding
Yes,
the
who is
letter.
the council? Ardhar.
were here only.
Who was there? Toshienda, but Toshienda will. Maybe if we call the executive engineer, then they'll come running.
Gotcha.
Maybe we'll call the executive engineer to appear in person.
Yes, sir.
I engineer coming.
Oh, come in. Okay. We'll wait for it. And we until 23. After everything.
But if some time may be required because we are awaiting the admissibility report. Lordship. The short date may be given. Lordship.
Okay, Mr. H. Alia, let's ask for the PWD. Please, time to obtain instructions and file affidavit. This is a matter of the 3 weeks. But we my lord, we have filed the affidavit today. Also. Yes, what is the
To go for a message.
Huh?
To go for a consent for the affidavit. Sometimes to be given.
Okay. Mr.
L. Thakuria.
N.
L. Thakuria.
Tapuria. Is your name here? In the
For Esther.
for appearing on behalf of Mr. S. Sharma, submit them. He needs time to go through the affidavit in a position filed by the respondent and file affidavit in a position if necessary. Prayers allowed. This is a matter after
2 weeks.
2 weeks.
Some date may be
2 weeks. Registry to place the affidavit in record. Affidavit in the position in the record. Okay. 2022.
My lord, this is about the forest royalty. On the last occasion, my lord has taken a note of one letter. That was,
So
my lord-
yes, we took note.
my lord, in this regard, we have written two communications to the petitioner, my lord, to submit the document so that we can,
No, your lordship, that is not required, your lordship. It was not.
You
there in
see,
the
the last order is that you have to submit this letter in the form of an affidavit.
no, my lord, we can further, no documents I got, my lord, I will bring these also in, that is what I want to say, my lord. Two documents, my lord. We have written to them, my lord. So, these also, my lord,
But that is not required, your lordship.
this is the inspection, my lord, that I have as of now, my lord.
Let us see what was to be done.
Page number 46 of the petition is the direction, my lord.
Did you make any payment of forest royalty?
No.
No. Are you sure?
Some amount it has, yes, Your Lordship, some amount it has been recovered from the bill.
So where is those bills?
But Your Lordship, in the contract, it was not mentioned that we have to produce the bill.
Look at the order passed by this court.
Yes, Your Lordship, but
What does it say?
Let's just follow the direction, madam, the direction.
What does the court say?
Lordship may come to page number 5, Your Lordship.
No,
The
please come to
conclusion.
the order of the court.
It's the order of the court, Your
Oh,
Lordship.
Okay, page
In
5.
absence of any contract condition.
Page 5.
In absence of any contract condition where a contract is unable to produce a certificate showing the use of forest produce on which royalty has been collected, the recovery from the bill against forest royalty cannot be made.
That is not direction. Direction is in page number 46. The court order, madam.
That's not answered.
Second last page, madam. Third last
47 page number, Your-
Come to 46. It starts from 46, madam.
46, Your Lordship, but the direction is in 47 in para 2.
Yes.
In the other cases, the employer shall forthwith release the pending bills of security. That is, in case of the, if such proof is not available, the authority shall be at liberty.
In those cases where the recovery has already been made, out here recovery has been made or not?
It has been made.
This, my lord. Yes.
The employer shall verify the contract of the petitioners, and if it is found that it is recoverable in terms of the determination.
My lord, two was my lord. Deduction of forest royalty from the bills of the contractor. And my lord, it has already laid down by this honorable court, my lord, there has been specific conditions, tender conditions will be there, that the contractor is liable to pay the forest royalty. That too in the event of any claim made by the forest department. In these types of cases, my lord, there is no such condition. There is office memorandum of finance department of 2002, I think, my lord, but it was not the part of the tender document. So this honorable court in C9 Associates directed the respondent, if you want to deduct forest royalty, then first incorporate those clauses and incorporate that ON. It was never done in this case, my lord. Therefore, this honorable court,
So they've got to follow which direction?
this one, my lord. This page 47. Page 47, Roman 2. And my lord will be covered by page 45 annual lordship.
You see, one thing you've got to,
Not specific, my lord.
no. You see, one
They have
thing,
to- they have to
you've got to
verify.
read first, the first part. The employee shall verify the contract of the petitioner's hearing.
Money.
And if it is found that forest royalty is recoverable in terms of the determinations and conclusions made in the present list are reasonable. Now, so the first determination you have got to do is whether forest royalty is recoverable or not,
Yes, my
in terms of the order, in terms of this case. Now, where is that?
That is what actually, that is what we wrote to them, that whether we have collected any.
That is not the issue. That is not the issue. It is like this. Whether Mr. Kuntal here is liable to pay income tax or not, please make up your mind. Then, if you come to a finding that he is liable to pay income tax, then you can ask for the payment
Yes.
receipts. But if you come to a decision that he is not liable to pay, then you return whatever you have already taken. So in same way, here you have got to first take a decision as to whether they are liable to pay forest royalty in terms of the contract agreement made. So that decision has to be taken by you first. Then the other issues will come into play.
We go to the tender conditions, my lord.
That's why they have got to go to
But
the,
they have to
they have got to go through the tender condition.
find any task force and they can any day change that.
Here, if I go by my that communication that we have sent to the petitioner, my lord, we have requested them to give us whether we have. If my,
No. Okay, you have asked them to give you. But first of all, why did you ask them to give you? Because you want to return them the money or what?
that
No, please. You cannot put the cart before the horse. You cannot say, please give us your receipts. Now, then we will think of whether you're liable to pay or not. That is not the way the court has directed. The court's direction is not that way. The court has not said that you first ask for the receipts. Court has said first take a decision as to whether they are liable to pay.
I understand. I will advise my client, my lord, to take up.
In terms of this, and in terms of this order, it appears that they're not liable.
And my lord, to the response to this letter, my lord, page 49, I categorically stated in my paragraph 7, page 9. Lord,
Anyway, let him take a, I think the client did not know how to proceed with this case. All right. Mr. Arda, counsel for the respondent, executive engineer, shall obtain instructions as to whether the respondent has taken a decision as to whether forest royalty is recoverable from the petitioner and thereafter comply with the other direction passed in the.
And that's another thing, my lord, I want to bring it in pilot topic. This respondent, my Midul Das, my lord, it's now 1 year, he has been promoted and he's in a different, he has become superintendent engineer.
Anyway,
My
you
lord, now problem with me is the content bit, my lord. He is not there. Now I have to communicate with the new income installment. And
we will
if he is not a party,
who is the new one? Who is the new person?
I will call the
find out the name.
And you give it to him.
That becomes easier for me.
This is the matter after 2 weeks. 2 weeks. How many matters have we got?
Deeply obliged, Lord.
Wait. Mr. S.C. Kal is here. That day he was not here. This is after 2 weeks. Yes, Mr. Kal. This review, why should we allow it?
No, what happened, there is some, because the notice was issued in 2021. So Supreme Court judgment is not.
So that clarification will make that it is 2021.
No, notice, so
This order is a consent order.
no, notice correct. So subsequently it was delayed. And in ground we have stated that the Ashish Agrawal judgment as well as the notification to subsequently, that is not applicable in this case. And immediately the notice was issued in 2021, March 2021. So it will, judgment will not be covered.
Why?
Because notice, Ashish Agrawal passed, because in 2021, there was an amendment in the income tax act. Notice were issued subsequent. There was a 2000 cases where tenants were postponed. And Supreme Court has given liberty to the department to issue fresh notice. But in this case, this is not applicable. Their notice is prior to that. So, the cases to be decided on merit. So their tenants the assessment and the assessment
This is a consent order.
no, that is correct. I'm not denying to that. We have stated also.
You go before the division bench.
Because the question of,
I don't find anything. It'll amount to a re-hearing.
because the matter is to be decided on merit. Because
So let the division bench send it back to the single bench.
you know, it may also to that effective.
I think because the problem is now. I don't know. It to me.
Huh?
Okay, I will take it up at 2. I've got some people.
On prayer for September 29, interim is there.
Item 29, interim order to continue to remain. To fact.
34. It's a 35. Seriously.
Yes, so no, so there was a challenge was made to the notice dated 30 March 21.
21. That was put under challenge. That was thereafter there was an amendment in the income tax act. Thereafter, about
Income tax act when? Amendment made when?
it was effective from 1/4/2021.
1/4/2021.
Onward.
Then
They challenged it and the notice, there was a misunderstanding, to be my fault, I could not sort out. They said that Ashish Agarwal judgment is applicable. But that is relating to that first amendment. They relied on one notification.
let us see Ashish Agarwal.
Not if, please to come to page 13. Rote pe kote, one paragraph,
18.
page 15, rote pe kote, paragraph 10.
Huh?
Page 15 of the EVP.
Page 15 yes.
Paragraph 5, paragraph 10 of Ashish Agarwal and paragraph 81 of the inspection dated 11/5/2022 are read to be below. In view of the above and for the reasons stated above, the present appeals are allowed. Part, the accused common of judgment, an order passed by the High Court in Territory Allahabad in the case number 20, Mother alleged petition is hereby modified and substitute is under the accused section 144 notices issued to the SEC, respective SEC, which were issued under unamended section 144 of the Act, which were the subject matter of the writ petition before the very respective High Court, shall be deemed to have been issued under section 148A of the IT Act and substituted by the Finance Act 2021 and constitute or stated to be proposed notice in terms of section 148A. The existing official shall within 30 days from the today provide to the respective SEC the information and materials relied upon by the review, so the SEC can reply to the proposed notice within 2 weeks thereafter. Two, the requirement of conducting any inquiry if required and with the prior approval of the specific authority under section 148A is hereby dispensed as a one-time measure vis-a-vis those notices which have been issued under section 148 of the unamended Act 1/4/21 till date, to those which have been passed by the High Court. So, if, here the present petition, the notice was issued in for the unamended Act,
Under the,
unamended Act, earlier Act.
let me show me the amended, show me the amendment.
It is.
Where?
And what their challenge was that the notice was there, so it was to beyond the time period. That was their what is the submission with regard to then admittedly the Ashish Agarwal judgment and notification is not applicable. So the judgment of the Honorable Supreme Court passed in the Ashish Agarwal case, the notice, the subsequent inspection issued on the basis of Ashish Agarwal, admittedly not applicable in the case.
Why? I don't know how. Show me how.
Because notice the notice,
Show me with the law. Don't show me, just say, just show me the law. Show me how.
approximate page 15 is the notice. It was issued on 30/3/2021 under section 148 of the Income Tax.
Yes, 148. So,
Approximate amended act is typed in the footnote of the this particular page. All
Yes.
147, 148, 148A, all sections were amended. And the effective date was from 1/4/2021. Only earlier it was reason to believe, and it was escape notice from the escape notice of the effect. That was the what was said.
I'm not getting it.
That was the basic difference also between the judgment pronounced by the Supreme Court in case of Ashish Agarwal Actually, this was a wrong application on the part of both the petitioner as well as the director. I am also notice the matter is referred to the second merit of the request.
No, a reasoning, this is a review.
Yes, no.
A review can it, if you, it's not appeal in disguise.
Yes, no.
Then
I know to notice what is the limitation of reviewer. If there is a error on the face of the report, then notice can
if there is an error on the face of the report,
your notice admittedly the notice was issued prior to the amendment, and the office Agrawal judgment is after amendment. Because notice were issued in
show me the unamended 148 and the amended 148.
that is available in the book.
Huh?
Please give her the book in book.
The book only shows which part.
No, of it in the footnote of the particular section. Unamended section is also there. Same section contains the amendment part, and the below notice is an amendment. If I take up on Friday, I'll place the Aziz Agrawal judgment. That- So, because that judgment is confined to the amendment provision of the income tax. That is why I so notice of the judgment. That judgment was partly allowed. Favor of the department. Giving more liberty, and on that specific notice, this notification was taken. Circular was. I've also annexed the circular, that is at page 19. So please go to, document, come to page 19, first paragraph. Will also clarify the point.
First paragraph.
Paragraph 1. The Honorable Supreme Court, by its judgment dated 4/5/2022, reported in point in the case of Ireno versus Aziz Agrawal, has adjudicated on the validity of the issuance of reassessment notice issued by assessing officer during the period beginning on 1/4/2021 and ending with 30th of June 2021. And in the extended time by exception and other laws, the exception of amendment of Central Provision Act.
So this one deals with basically the amendment.
Yes, amendment. And after admittedly, the notice was issued prior to so the whole provision of that.
Instead of, let's issue notice, let us hear the other.
Sure.
But,
So that will be.
there's 6 years for the review petition. Submit the June order dated 21/11/2020. Passed in 7116/2020. Has to be reviewed in as much as the case was disposed of in terms of para 10 of the judgment of the Supreme Court in the case of Union of India and others versus Ashish Agarwal. reported in AIR 2022 SC 278. He submit that the Supreme Court in Ashish Agarwal was seized of notices, seized of notices issued under the amended section 148 of the Income Tax Act. While the case of the respondent the case of the opposite party hearing was in terms of the notices issued under section 148 before its amendment. So he submit that the amended section 148 of the Income Tax Act came into force with effect of 1/4/2021. That is that is after the notices were issued to the opposite party. But this is it is a consent order.
That was the making mistake.
Issue notice returnable in 3 weeks. You will take steps. If you don't, if
I'll step by tomorrow.
Mr. SCKL, no, the review petition shall take steps for service of notice upon the respondent by registered post with AD. It will be in 2 days. List the matter after 3 weeks.
Okay.
Then one is certified also same thing. No, wait.
Same.
Give me 36. All this one. Okay, all same, huh?
Okay.
Let's give back this. Yes, who is appearing? So, what are you going to do? You are for whom? Respondent number?
I am for 1 and 4, but we have not started.
Yes, madam. Extra copies.
Yes, perfect. So,
Yeah, I think it's-
okay, that's it.
Mr. G. Bakalian appearing for respondent number 1 and 4. Submit that he has not received extra copies of the repetition. So submit the
ANI,
A,
ANI.
A and I Hussain. Learned counsel for the respondent number 3 and Miss El Bora for respondent number 2 and 5 are granted 3 weeks time to file affidavit of proof. This is the matter. N Bora.
There is this case, my lord, I have filed an IA.
Yes,
IA for non-allotment of visa and room to without leave of this court. Because, my lord, we are running the business in Lanka regulated market from last 10 to 15 years. Even, and in fact,
where is the other side? All the others.
after success. Because of similar nature of case, my lord, earlier disposed of by this honorable, directing the deputy commissioner to inquire the.
To inquire the matter. But anyway, they have to be here. The other side have to be. I'm doing item 6.
Actually, sorry, my lord, when this matter was called, my lord, I was the board. My lord, your lordship posed a query, my lord, as to why respondent number 5 is a party. Respondent number 5 is a party respondent because the work order was issued by the respondent number 5. The work belonged to the water resource department, but they have outsourced it to respondent number 5 who have issued the work order to us.
So, but then you have not taken steps.
My lord, that is fine. I apologize. Today we have taken steps.
Okay, right. Mr. M. Biswas, Learned Counsel for the petition of public, that step for service of notice upon the respondent number 5 has been taken today. Ms. A. Loda appears
Water Resources Department responding 124.
for respondents number 4, the Water Resource Department. Full stop, Miss. B. Raba appears appears on behalf of Miss A. A. Counsel for respondent number 6. 6 and 7. And Miss Long. Right down. Appears on behalf of Mr. R.K. Tarukdar. Let's counsel for the respondent number 8. This is a matter of COVID.
And review.
Then in all the other cases,
Absolutely. Take. I take it.
time being 38. Mr. Ray. This is the last. Yes.
My lord, the judgment, my lord, not the right.
Yes.
Similar nature of it.
When was this building completed?
My lord,
When?
I thought
These writ petitions are of 2014. And
That is
20 and
separate.
all, huh?
That was separate.
Maybe. 2020 writ petition. And you're coming after 4 years.
No, no, 23, in the month of September 23, my lord, the building was, the construction was over.
Now tell me what is, okay, what is your number? They made a list of earlier beta holders.
Yes.
Where is the earlier beta holders?
So, that is into my lord, the one. So my,
Your writ petition has no annexures.
my read meeting.
Huh?
My read meeting.
Yes.
From annexure 1 onward.
Okay, this is the IA. Yes.
My lord, page 21 onward.
No, I'm not on this. These are nothing. Where is the list of earlier beta holders? You don't have that.
Okay, and it's okay.
Yes, he says that he was a beta holder earlier.
Yeah, we can proceed. I is also not with you.
So that you see what has happened is he says that in this Lanka wholesale raw vegetable market, he was a beta holder and the municipal board constructed the RCC building. Now he wants a room.
So that part was the exponent of 5,765.
Huh?
Exponent of 5,765.
So the thing is that you see we cannot decide this issue here. We do not know. So let it be decided by the deputy commissioner concerned or what or by whom.
It's by the lordship municipal board, certificate with the municipal board of chairman municipal board.
Yes, actually, I don't think deputy commissioner also has got any role to play.
We have no role. Deputy commissioner. Even they have also lordship. Before a representation before the chairman of the municipal board.
Let the municipal board consider.
Lordship. The annex of 5, page number is not there, probably last 2 pages.
You were never having a room. You never had a room. Correct.
Earlier, my lord, it is temporary shade.
Shed outside.
Yes.
So the now
Now, means that, my lord, after completion of, my lord.
so your prayer is what? That your case should be considered by them.
One priority.
Correct. Right, Mr.
Yes, sir.
S. Chaudhary, land counsel for the petition. Also heard Mr. K. Gogoi appearing for
I am for number 1, 2, 3, 4 and 6 lottery, 1 by UDT lottery.
1, 3,
Lottery, I am for 2, 3,
2, 3,
4 and 6 lottery.
4 and 6. Mr. G. Bokalial appears on behalf of number 1.
No, same way.
UDT. UDT department.
Who is the good author?
P Nayak is there. P Nayak.
So, can you call him?
He's present in the court.
There's no point keeping these cases pending. We cannot decide this issue.
No, directing them into the proposal to decide.
You
Plastic farming, plastic. My channel be here of even partner में side.
how you can go? Only Mr. P Naik is coming or not?
No, I informed me, junior,
On legs.
around.
Who is appearing for this number 5? No one is here. Notice issued on 22/3. Okay, right. Heard Mr. P Naik for no Mr. P Naik appears for his point number. Oh, he was here earlier. P Naik is his name, is it? For his point number 1. So no one appears for his point number 5. Even the notice was issued to the point number 5 on 22/3/2020. Next one. The petitioner's case is that the petitioners have been running their permanent wholesale raw vegetable business in their individual vitas in the Lanka wholesale raw vegetable market, made out of in Tinchet, in temporary Tinchets. However, the Lanka Municipal Board constructed a concrete building, is it? For running the Lanka wholesale raw vegetable market. The petitioner's grievance is that the Lanka Municipal Board has been collecting money from businessmen for allotment of the vitas in the new concrete building. Completed on? Completed when?
Completed, my lord, on 2/9/23, my lord, notice was
Completed in the month of August. August, September 2020. Next up, the petitions council submit that the Lanka Municipal Board has been collecting rupees 5 lakh from various persons for distribution of forms for allotment of vitas in the new building. Instead of allotting the vitas like rooms to the petitioners. He submits that the petitioners have submitted a representation dated to what date?
29/23.
Page 44. What is the date? No date.
It's a representation on 23/9/23 to the district. Police.
Have submitted representation dated 23
Right.
9/23 to the
District police.
no, I'm chairman. The district commissioner has got no role to play. He
My lord,
doesn't know anything.
actually, last page, my lord, and extra 5,
Yes, that's what-
2/11/2023.
at 2/11/23
2/11.
to the chairman Lanka Municipal Committee, comma, Lanka, comma, Hojai. Praying for allotting a vita to the petitioner. As they have been doing day-to-day business in the Lanka Municipal Vegetable Market for more than 20 years. The petitioner's counsel submits that this writ petition can be disposed of if the respondent number 5 takes a decision on the petitioner's representation dated within a specified time. Mr. G. Bokala, learned counsel for the respondent, no, Mr. K. Goy, na?
Yes.
K. Goy for the respondent number 2, 3,
4 and 6.
4 and 6. And Miss R.M. Bora for P9, appearing for respondent number 5, 4, 1. Okay, also you put for R.M. Bora in the beginning. Submit that they've got no objection to the prayer made by the petitioner. In view of the consent of the parties, the respondent number 5 is directed to take a decision on the petitioner's representation dated dash, within a period of 1 month from the date of receipt of a copy of this letter. Full stop. And full stop, the decision taken thereafter be communicated to the petition. This petition is accordingly disposed of. IA to in view of the order passed in the main case, the IA is also disposed of accordingly. That's all.